And now we're going to go to public hearings, starting with Senate Bill 5066. We're going to start with hearing from staff. And thank you, Senator Hansen, for your patience and for being here. Go ahead, Joe.
Thank you, Madam Chair. Before you now is a proposed substitute to Senate Bill 5066, which concerns local law enforcement and corrections agency misconduct through investigative and legal actions. Under the Washington State Constitution, the Attorney General is empowered to act as the legal advisor to state officers and is required to perform other duties as may be prescribed by law. Under this auspice, the legislature has empowered the Attorney General to appear for and represent the state before the Supreme Court and courts of appeal in all cases in which the state is interested, to institute and prosecute all actions which may be necessary in the executions of the duties of any state officer, to defend all actions against any state officer or employee acting in their official capacity, and upon written request of the governor to investigate violations of criminal laws. Likewise, the Attorney General is empowered to perform any other duties that are or may be from time to time be required by the Attorney General under law. If enacted, the proposed substitute to Senate Bill 5066 would grant the Attorney General the specific authority to investigate and bring actions against local law enforcement and corrections agencies for violation of the state constitution and state laws. This grant of authority would include the ability to investigate local law enforcement and corrections agencies for violations of the law and the state constitution, the authority to issue written and civil investigation demands for documents and testimony, and to institute civil actions for injunctive or declaratory relief, damages, costs, and reasonable attorney's fees. The authority granted to the Attorney General under this bill is not intended to hold individual officers liable for misconduct. And when conducting an investigation, the Attorney General must confer with the Department of Justice to ensure that there are no conflicts between the two offices. And if the subject of an Attorney General investigation is also the subject of an active DOJ investigation, the Attorney General is prohibited from seeking any relief or remedies that are in conflict with the federal action. After the effective date of this bill, no public employer may enter into or renew any collective bargaining agreement that conflicts with the provisions of this act. And by September 1st, 2026, the Attorney General must develop and publish model policies for law enforcement agency accountability systems. The model policy must be consistent with the standards adopted in other Attorney General published model policies, and must specify model practices for receiving complaints of serious misconduct, conducting investigations of serious misconduct, imposing discipline for serious misconduct, and addressing disciplinary appeals. Finally, the bill requires the Washington Association of Sheriffs and Police Chiefs to establish a program to provide technical assistance to any local law enforcement or corrections agency that is under investigation. A fiscal note has been requested for this bill, and I'd be happy to answer any questions.
Thank you so much. Senator Holy does have a question.
I've got two. Thank you, Madam Chair. So at 20,000 feet, when I do the numbers on this real quick about the people that have signed in pro or con versus the actual list of people by identification, there's about 1,200 that are total pro and con. There's about 450-ish kind of thing that actually show up as listed on this. Is there the potential for future reference, but in this bill also the potential for somebody, if they are not identified specifically in the queue following, to come back in, for example, anonymously and vote a dozen times? In this type of, is that potential exist?
And Senator, under our system, when a person signs in to testify, specifically to testify, if they sign in multiple times, our team will go back and delete those duplicate entries. But that is not the same for individuals who sign in for just either pro, con, or other on the bill. So there is the potential that someone could sign in multiple times. I don't believe it allows anonymous sign-ins, so they would have to provide their information. But the system is not capable of detecting when one person signs in multiple times on a single bill.
Fair enough, understood. So that if there's a significant difference between the two, the potential exists. Follow-up question, Madam Chair.
Sure, Senator Holy.
Okay, so looking at this, I understand what the express intent was in some of the preamble to the legislation. At the same time, this does not have the intent to target, for example, an individual officer. Concurrent with that intent not to, does the potential exist for this bill, for example, if the Attorney General's office believes that a given jurisdiction's chief officer, sheriff, police chief, this kind of thing, did not perform an adequate investigation of an officer's misconduct, or has a potential to review it and say that the discipline imposed was inconsistent with what they believe is appropriate, do they have the ability to step in that capacity and address the individual officer's behavior if the agency is not subjectively doing something they think is appropriate?
So, Senator, the bill discusses the AG's office coming in situations of systemic issues with law enforcement agencies or corrections agencies. I don't believe that the bill does define what that idea of systemic is. I hesitate to speculate on individual circumstances. But I believe that there would be some requirement that it be more than just a singular anecdotal instance of misconduct. And I think that would be a question that would be litigated, whether or not something rises to the level of systemic or if it's individual distinct cases of misconduct.
Appreciate that. Thank you.
Senator Wagner and then Senator Fortunato.
Thank you, Madam Chair. Curious about the portion that affects collective bargaining. I'm having trouble figuring out how that is important to the bill, and maybe it's a question for the prime sponsor if you don't have that, because it kind of goes to intent, but maybe you have a scenario that you could opine about how that is pertinent to the main intent of the bill.
And Senator, unfortunately, I don't have that, but luckily Senator Hansen, the sponsor of the bill, is here and much smarter than I am. So I believe that he'll be able to answer that.
Excellent. Senator Fortunato.
Would it be fair to say that if somebody says a problem is systemic, that is the default of that organization? In other words, the default is they are this way. They are doing whatever it is that we're saying. We have this systemic problem of this. And would it be fair to say that the default of that organization is that that's what they're doing as a baseline, as opposed to something that happens occasionally?
Senator,
I'm just trying to get a definition a little more of systemic.
right. And again, I don't believe that is defined here in this bill. And so I hesitate to jump into the position of a litigant in this case to try and define that. I think the sponsor of the bill or the advocates of the bill might be able to answer that a little bit better than I can, because I just hesitate to get into that position where I'm taking a position.
Thank you.
Thank you so much. Any other questions for staff? Thank you so much for that, Joe. And now I'd like to welcome Senator Hansen to the Law and Justice Committee. Thank you so much for being here and patiently waiting while we finish exec. And please do tell us about your bill.
Thank you, Madam Chair, Ranking Member, members of the committee. Thank you for your time, and thank you to Mr. McKittrick for that excellent introduction. No one on the planet is smarter than nonpartisan Senate committee staff, certainly not me. So you could have heard me shouting fake news from the back when he said that. This bill clarifies the Attorney General's existing authority to investigate and file what are sometimes called structural lawsuits for patterns of conduct. To back up a step, the committee probably knows and heard from the briefing, the Department of Justice has had this authority for many, many years and has used it in many, many places, including, for example, in the city of Seattle. And the idea is that when there are significant patterns or practices of misconduct, it is a way of providing some sort of oversight. It is overseen by a court. A court has to make an independent decision on what to order. It's not like the Attorney General or the Department of Justice just gets to enforce things that it wants. There needs to be a judge who orders certain remedies, but it's really directed at kind of getting upstream at a department level if things are going really wrong. This body has done a lot of remarkable work on law enforcement accountability, something that I put in the budget a few years ago related to accreditation. So some of you may know an accredited agency is basically a set of best practices of professionalism. Do you have a use of force policy? How's your evidence room? And we put some money in the budget that we have now dispersed to a bunch of agencies around the state to get accredited or get reaccredited to bring them up to that kind of top level. And this bill, I feel like, is in the same sort of, this bill is in the same area. We are looking for kind of professionalized and best practices. I think I've forgotten most of the questions, but I think I remember some of them. We have worked extensively with our colleagues in law enforcement on this bill. You will hear, I think, a mix of testimony of con and other. So we're trying to be responsive to like workability concerns as they're raised. The bargaining point was at the request of one of our colleagues, and I don't know that we've actually got it right, but the idea was that we're not attempting to change by law existing bargaining arrangements with this bill. But, you know, we're obviously open to more suggestions from both our colleagues in law enforcement and our colleagues in local government, and respectfully appreciate the committee's support. Thank you for hearing it.
Thank you so much. Senator Holy has a question.
Well, thank you, Madam Chair. Senator Hansen, I love that, you know, versus representative. Years ago, we sat across from each other, and I rather enjoyed the time in committee with you, I have to tell you.
Indeed. Likewise.
You're a good attorney, is what you are. So just a thought on this, but is this legislation possibly a policy statement or a clarification? Because as I look, it appears that the Attorney General's office has had this authority all along. They've just never thought to exercise it.
So they have used it. There's a case, I think it's City of Sunnyside, but the problem is sometimes the Attorney General has broad authority to litigate in the public interest, right? There has been questions raised and it's been litigated, oh, is this type of thing within the Attorney General's public interest authority? I mean, I think it clearly should be, but to remove any doubt that it's actually within the public interest authority, that's what this bill does. So you're right to point out, I mean, the Attorney General almost certainly already has this authority to prevent any questions about it is the point of this bill. Thank you.
Thank you so much. Senator Torres.
Thank you, Madam Chairman. This might actually be for staff, or if you can answer it, I mean, feel free. And thank you for being here. The City of Sunnyside, you mentioned that case. Can you forward a copy of that over?
I'm sure someone can. I don't have, I'm sure someone can. I don't have the pleadings, but someone can for sure. I'll make sure they do. Thank you.
Thank you.
Thank you. And we can have staff follow up on that. Any other questions for the prime sponsor? Seeing none, thank you so much, Senator Hansen, and thank you so much for your work on having the hearing on the proposed sub. I greatly appreciate that. And with that, we're going to call our first panel, who are all in person. We're going to start with Shelley Washington, Antonio Ginata, and Kelly McConney. Please do come up, introduce yourselves, and begin. And following them is going to be Candace Bach, James McMahon, and Ryan Lufkin. Good morning.
Good morning, Chair Dingra. Good morning, Vice Chair Trudeau, Ranking Member Holy. My name is Antonio Ginata. I'm the Policy Director at Columbia Legal Services. I'm testifying in support of the proposed substitute 5066. Columbia Legal Services is a civil legal aid organization here in Washington State. We represent low-income residents of Washington who can't access federally funded civil legal aid because of their immigration status or because they're in prison or in jails. And we at CLS have litigated cases on behalf of our low-income clients against local governments who have violated state constitutional rights. For example, we sued King County a few years back. They were putting young people and children in solitary confinement in their jails, and our clients alleged that their Washington state constitutional violations, that Washington state constitutional rights were being violated, particularly Article 1, Section 14, prohibition against cruel punishment. But we are a very small civil legal aid organization. We do not have the capacity to take on every potential violation by local governments of Washington state law. We look to the private bar, and the private bar does not often take on these cases. And so that's why we think this proposed substitute helps to fill that gap in coverage. It clarifies some of the investigatory responsibilities of the Attorney General and what they can look at these violations to make sure to enforce state law and the state constitution. You are the legislature. When you pass laws, when you establish rights, you expect folks to follow those laws and enforce those rights. And what this bill does is help to clarify that. So we commend it to you, and thank you for your support, and thanks for your time.
Thank you so much. Shelley Washington is actually joining us remote, so please unmute, introduce yourself, and begin. Good morning.
I'm sorry about that. Can you hear me?
Yes, we can. We can hear you and see you.
Thank you. Good morning, Madam Chair and member of the committee. My name is Shelley Washington. I'm testifying today on behalf of Washington Coalition for Police Accountability. We support proposed Senate Bill 5066. We think the Attorney General's office needs the pre-litigation tools that this legislation provides. And we like the processes set up for early resolution with local law enforcement agencies and jails. You will hear today from others that this legislation is not needed. You will hear that police don't engage in misconduct. I couldn't disagree more. On October 29th of 2020, my nephew Kevin Peterson Jr. was killed by Clark County Sheriff deputies at the age of 21. Unfortunately, I have experienced the systems at play. Both the Clark County Sheriff's Office and the Vancouver Police Department have a history of using excessive force against people of color, Pacific Islanders, and those with mental health disorders, in a county where Black people and Pacific Islanders make up barely 3% of the population. According to the local agency's own records, people of color are constantly overrepresented in cases and use of force. Due to the history of excessive force, the Vancouver NAACP and ACLU requested a few years ago that the U.S. Department of Justice investigate the Vancouver Police Department and Clark County Sheriff's Office. We have yet received a response. This illustrates why the state legislators must craft a solution for Washington state. This legislation will work to reduce racial and economic disparities, protect civil rights, and ensure that law enforcement's practice aligns with modern standards of justice. These changes are crucial in building trust between the public and law enforcement, especially in communities that may feel and may be targeted. Thank you for your time.
Thank you so much. Next up is Kelly McConney. Good morning.
Thank you, Madam Chair. My name is Kelly McConney Moore, for the record, and I'm the Deputy Director of Legislation at the Policing Project. We're a national nonprofit based at NYU Law, and we focus on ensuring democratic accountability in policing. We strongly support this proposed substitute. If passed, the Attorney General would be able to ensure that every community in Washington is receiving an equally high level of policing free from bias or unconstitutional practices. Other states, including California, Colorado, Virginia, Massachusetts, Nevada, and more, already allow their attorneys general this kind of power, and they have benefited. In just one example, complaints against police officers in a California city went down 80% following a consent decree, and this reduction has lasted for over a decade. There are numerous instances of this kind of substantial and lasting change. One of the most important things this bill provides is several pre-litigation tools. The bill gives the Attorney General the power to issue written demands for documents, testimony, answers to interrogatories. With these tools, the Attorney General can help law enforcement agencies avoid litigation altogether or identify fixable problems that can be solved through negotiation without the need for a suit. We think these tools are crucial to save resources and avoid the hassle and potential reputational damage of litigation. Right now, it's particularly critical that the Washington Attorney General have this power. Even under the best of circumstances, the federal DOJ cannot address all agencies with a pattern or practice of constitutional violations. And right now, even fewer issues are being addressed since all new civil rights investigations are currently halted. There's definitely a need in Washington state. From 2017 through 2022, Washington cities and counties paid over $100 million to resolve lawsuits arising from allegations of police misconduct. This does indicate that some agencies may have widespread problems and investigation might be merited. We believe that with this bill, Washington can make significant strides in public safety and high-quality policing across the state. We support the proposed substitute, and we urge you to recommend passage. Thank you.
Thank you so much. And I will hear from Candace Buck, James McMahon, and Ryan Lufkin. Go ahead, Candace.
Thank you. Good morning, Chair, members of the committee. Candace Bach, representing the Association of Washington Cities. I'm here opposed to Senate Bill 5066 as an unnecessary expansion of the Attorney General's authority. We appreciate the bill proponents for reaching out to us to explore options, but we just don't think that this expansion of authority is necessary. As you heard, the Attorney General has broad authority. They've brought a suit against a city. The State Supreme Court upheld their authority to do so. This bill essentially gives the AG pre-litigation subpoena power, as you just heard from the previous testifier, and the section in the substitute on liberal construction of the act creates even more confusion and uncertainty for local governments about what does this all mean and how deep does this go. We're concerned that this expanded authority, without the need to be willing to take that step of filing litigation, will result in unnecessary expenditures of resources and create confusion and conflict with other ongoing investigations. For example, we think it's possible that if the Attorney General comes in to do an investigation, they could potentially grant immunity to an officer for their cooperation. That could upend an investigation into the discipline if that officer is subject to it. So the coordination and the impact could be felt much further. The fiscal note for this bill indicates that the Attorney General's office would need to hire 10 FTE at a cost of about $3 million. So clearly, they would be intending to use this authority in frequent ways, which again could drive up not only costs for the state, but for local government in responding to this, taking away resources from what we think is really necessary. We're also concerned about the language regarding collective bargaining and how it might work with binding interest arbitration. It could put a city in the middle of two laws, needing to comply with the binding decision of an arbitrator and needing to comply with this. One would hope that that would not happen, but it is binding arbitration after all. And if that's the decision of the arbitrator, the city could be kind of caught between the two laws. Finally, this proposal really creates a one-way street. Under this proposal, the Attorney General's office is allowed to collect reasonable attorney's fees if they prevail, but the jurisdiction doesn't have the same ability if they prevail. So, I think it's important that really is a two-way street and that both parties have the same incentive when it comes to the litigation. So we think we appreciate the intent here. We think the Attorney General's office has this authority, and we don't think that this bill is necessary. Thank you.
Thank you so much. Go ahead, James.
Good morning, Madam Chair and members of the committee. I'm James McMahon, Policy Director with the Association of Sheriffs and Police Chiefs, here in strong opposition to this bill. Senate Bill 5066, we believe, will undermine your efforts to recruit and retain additional law enforcement officers in this state, just as our officers paid attention and we think were encouraged by your actions last week on Senate Bill 5060. We think they are also paying attention to bills and hearings like this. We think the state should be helping Washington's law enforcement agencies, not suing us. It's easy to say when you're the plaintiff that you're helping the respondent in a lawsuit, but as the respondent, it rarely feels like help. Let's remember that the Washington Attorney General is a substantially different role than the United States Attorney General. The Washington Attorney General is not the state's chief law enforcement officer. Many have argued, and we actually take a different position than our friends in the cities, many argued that the Attorney General already has this authority. When we read the rest of the sentence that's most commonly cited in that statute, it specifically says, in the state Supreme Court and the Court of Appeals. When we look at the Sunnyside case, many often forget that that's a case about a housing program, not about the law enforcement related activities of the city of Sunnyside. Under this bill, neither a pattern nor a practice is required. I'll point your attention to Section 3, Sub 1. We think the mere curiosity of a single alleged violation is enough to bring a local law enforcement agency to its knees, except for state law enforcement agencies. That's a problem in our view. As you heard from Ms. Bach, the $3.7 million state agency fiscal note, I will point out, is enough to hire more than a dozen law enforcement officers in this state. Getting close to wrapping up, we think if the Attorney General is to become the watchdog of Washington's law enforcement agencies, the legislature must first divest the Attorney General's office of all law enforcement related activities so as to ensure there's no conflict or perceived conflict of interest there. And I'll wrap up with this. Just a few years ago, when many Washingtonians called their sheriffs and police chiefs and said, hey, what are you going to do if the federal government comes to take all my guns? We were able to tell them the good news is we are a locally controlled law enforcement agency. We're controlled by the voters and elected officials here. That's not going to happen. Today, when people call our sheriffs and police chiefs and say the federal government's going to round up all the immigrants in our communities, we get to say we are locally controlled law enforcement officers controlled by our communities, not the federal government. We fear that this, what we will characterize as the state always knows best. Let's not forget that even Washington could see an ideological change. We wonder whether the proponents of this bill would continue to support the policy here if the Washington Attorney General took a position like, frankly, what we've seen the United States Department of Justice do in the last 2 weeks. We saw a memo come out to all Assistant U.S. Attorneys Generals that we think indirectly threatened criminal or civil action against local law enforcement agencies for failing to cooperate with federal immigration authorities. We don't think that should be the case either at the federal level or at the state level. We ask that you partner with us so that we can accomplish our shared goals of providing help to people who need help and reducing victimizations. And we think that this bill hurts that effort rather than helps it.
Thank you, James. I do have a question for you. You know, I've been a prosecutor for 20 years, worked with some amazing law enforcement officers. Also heard from some excellent detectives and law enforcement officers that many times the culture in those agencies, or maybe a few people in charge, are not necessarily helping the officers who want to do the right thing, who want to use the training they have gotten. And this, in my opinion, will ensure that our law enforcement officers who really have the right training and want to help people, that they have an option in ensuring that the culture of where they work is consistent with the training that they have received. So I'm a little confused as to why you think this is going to hinder recruiting, because what I have seen all across our state is that there are law enforcement agencies who don't have a problem hiring, and there are the law enforcement agencies that do have a problem hiring. And a lot of it speaks to the work culture at those agencies. So why would a bill like this, where we are saying that, hey, all you great officers who are trying to do the best you can, we have your back in ensuring that you have the work culture that is in line with your values and your training?
Yeah, great question, Senator. I'll refer back to the part of my testimony where I referenced that the respondent in a lawsuit doesn't often feel like they're the one being helped here. But I do want to agree with your premise. Culture is a big deal in law enforcement. We know that. As an association, and I was happy to hear my friend, the prime sponsor of this bill, talk about accreditation, because that's been our approach. Aside from any legislative effort, that's been our association's approach over the last 10, 15, 20 years maybe, particularly through our accreditation program that we have chosen to administer. And we've been nationally recognized for how great, frankly, not to brag, but how great our accreditation program is to address that very issue, right? We can accomplish culture change through a variety of ways. We choose to do that through assisting, through providing help to establishing those standards and providing incentives for those agencies to accomplish those things that we all agree to. It's a much different approach than this bill, which seeks to accomplish that through litigation.
Thank you. Hopefully we can all work together towards the same goal. Senator Holy and then Senator Wagner.
All right. Thank you, Madam Chair. I want to throw out some ideas, and I want you to comment on them, whether they're accurate or not. It appears almost that this is redundant. And on that thought, you currently have within a department an internal affairs group that has the potential to terminate, refer for prosecution. We've seen that a lot in the last 10 years. Here you have a lot in some of the larger cities, an ombudsman program that has complete autonomous statutory ordinance-based authority out there that can perform the same outcome, same service. You have the Criminal Justice Training Commission that just recently was given authority to control everything from hiring all the way through termination and referral again in one agency, a state agency on that. And of course, you still have DOJ, that has imposed over the last 20 years, 25 years, the consent decrees for departments that actually have this systemic problem and or the ability to bring action under Title 42. All this being in place, it appears some of it's redundant. And my problem on this is that, to Senator Stinger's point, there's always going to be the bad hires. But that's not the problem in the last 7 or 8 years. The problem is hiring, period. And the issue is perception on this by the public about whether they want to become police officers. When these things come along here, it's not a matter of whether they have a specific utility. It's a matter of whether they have an impact on public perception here. And you have people who would be interested in taking the job. So all this being said, do you think that there's a potential here for maybe having internal affairs, ombudsman program, CJTC, DOJ? Does this add a fifth ability, a fifth level of being able to take that fifth whack at the piñata, so to speak here, that everybody can have something they could do independently, and where you could venue a forum shop until you come up with somebody that's sympathetic here, and yet there is no double jeopardy, for example, concurrent jurisdictions, federal and state, or separate state agencies can come back, try it again. I mean, the political impact on this scares me. So my thought was this would probably be a much better placed piece of legislation in the Office of Independent Investigations, where you could control something like this and have a degree of autonomy, maybe for some place that's not overseen by an elected position. Am I wrong? Am I right?
So thank you, Senator. I'm not sure our position on this bill would change if it were housed in a different state agency. It's the contents of the bill, not who administers it. But to your other question, I think this would be at least the fifth layer. I think your recitation left out private litigation, which I disagree with my friend from the Columbia Legal Services. We don't seem to have a shortage of people willing at least to threaten litigation against us. And your list also left out that there are several instances, I'll refer to use of force model policies and use of force data reporting, that the state, through the Attorney General's office, also requires their agencies to do. We don't shy away from accountability. We also don't shy away from the reality that as long as we have humans doing these jobs, of course we're going to make mistakes. We should assist our local law enforcement agencies in accomplishing our shared goals through help and incentives rather than punishments and lawsuits.
Senator Wagner, you had a question?
Thank you, Madam Chair. Yeah, you brought my attention to something in your testimony that probably I should have noticed in reading the bill title, but this does not apply to state agencies.
Correct.
And is that handled in another way? So assuming I think that we need yet another lens to look at this problem, why would a state agency not fall under that same lens, or is it handled in another way?
I think it's only appropriate for me to answer the The second part of your question, I think maybe the prime sponsor, somebody else could answer the first part about why. To your second part, I'm not aware of any other mechanism under state law that would be similar to this for state law enforcement agencies. This is just focused on locals.
Thank you. Senator Trudeau.
Thank you. I had one pointed question, but I'm hearing, I heard something about a $100 million payout. We passed through this committee a $100 million investment. To make dollars work, I think often we need to ensure compliance so that we don't have these $100 million lawsuits that then negate the $100 million that we're putting in. And so I think a lot about what I see when dollars are at play. And litigation is absolutely a good tool when you're talking about dollars and cents related to the way people operate to get folks into compliance. That leads me to my question, James. How many agencies are currently in compliance with the policies that you referenced? For example, Keep Washington Working. It is my understanding that not all agencies across the state have adopted those policies, are in compliance. And then additionally, you mentioned the use of force model policies, which again, my understanding is not all agencies are in compliance with those either. So how can you reconcile what you're saying about a tool to ensure that we are asking and going to make sure that we're overseeing compliance?
Yeah, thank you for that question, Senator. I'll first point out that I think we shouldn't assume that all payouts in litigation are systemic problems, that this bill talks about systemic problems, but the operational language as we read it actually references a violation. Some could be, but I don't think we can generalize that, and maybe an analysis of that could prove me wrong, and I'm open to that. To your questions about Keep Washington Working model policy and the use of force model policy, let's not forget that each local law enforcement agency has to at least be considerate of their own legal advisor's interpretation of the statute. And I think where there's disagreement, for the most part, there could be outliers there. Where there's disagreement between those model policies as proposed by the Attorney General's office and the actual policies by those agencies, I think there are reasonable and rational reasons why. Again, I'm not going to make that a universal statement. Of course, there could be exceptions there, and I think we should discuss those. But I think they have to consider that the Washington State Attorney General is not the legal advisor for any sheriff's office or any police department. And I think those are model policies, and I think the actual policies are informed by the experiences of those local law enforcement agencies in consultation with the one who's actually going to defend them against lawsuits.
Quick follow-up, Senator Trudeau.
Thank you. So am I hearing correctly that you're saying that every agency across the state has adopted some way to address immigration issues and some way to address use of force policies? Are agencies in compliance with the requirements in those, regardless of whether they've adopted the model policies or not? You made some pretty clear statements about how agencies are not, going to work with the federal government on immigration enforcement. Does that mean that every location, every agency has their own policy to ensure that?
There's no way that I could guarantee you, Senator, that's the case. And I think I took intentional effort to make sure that my statements observe that fact, right? I can't make a blanket statement about all 276, if I remember right, law enforcement agencies in this state. I don't have the opportunity to go read all of those policies. I also said earlier, so long as we have humans doing these jobs, we understand mistakes are going to be made. I think my overall point is we think the state should help us do those things right rather than suing us.
Madam Chair, may I?
Yes, please, go ahead.
Thank you for your indulgence. I just wanted to respond to the $100 million settlement number that got tossed out there. I don't know exactly where that number came from, although I may not be surprised by it just because of the broad waiver of immunity over liability in our state means that we do get sued frequently. And whether the suit has merit or not, it's usually cheaper to settle, unfortunately, because litigation is just so very expensive. So while that's a very large number, it may not be as telling as it might sound because, again, it's cheaper to settle than to pay attorneys to fully litigate something. Thank you.
Thank you. Senator Fortunato?
Thank you, Madam Chair. Kind of a two-part question. One, do you think that the interpretation of this statute would change on one administration in the AG's office to another. So should one AG may interpret it one way, and another different AG may interpret it differently. Do you think that or do you think that this, the bill outlines that it would be consistent no matter who would be the AG, subject to interpretation or not, is the question.
So it's hard to predict the future, Senator, but if I give it a shot, I would surmise that the authority in this bill, frankly, is pretty clear. The Attorney General, as we read it, could bring an investigation, and we characterize bring a law enforcement agency to its knees based on something as simple as curiosity. We hope that that wouldn't be the case, but I think that interpretation would be consistent, frankly, across attorneys general. I think where we would see the difference is what kind of issues they would bring a law enforcement agencies to, or consider bringing those actions under.
And if I may, a very quick follow-up.
Very quick.
Would you suggest that maybe we could help limit the impact of these lawsuits by having price controls on attorneys' fees?
I think that's a much larger discussion on the whole legal field.
An excellent question, Senator, but I'll just leave it at that, perhaps.
Yes, thank you. And with that, we're going to go to hear from Ryan, who's going to join us remotely. And on deck is going to be Shalia Stallings, Alai Lima, Michael Tranzu, and Heather Kelly.
Good morning, Chair, members of the committee. My name is Ryan Lufkin, and I speak today on behalf of the Washington Council of Police and Sheriffs in strong opposition to Senate Bill 5066. This bill would create ambiguous authority for the AG to roam the cities and counties of Washington and sue these jurisdictions over any single perceived violation of the Constitution or any law in the state of Washington. Unlike pattern and practice suits that the federal government may bring, this law requires no pattern and no practice of anything. To be clear, the text of the bill does not require anything systemic. A single violation somewhere would be sufficient to start a ruinously expensive lawsuit. The law specifies no burden of proof, no requirement of a pattern or practice, no requirement to show that prior efforts of a city or town have failed to correct some sort of systemic problem, no timeline for the AG to complete their investigation, nor any timeline for the AG to finish the suit. Just an incredibly broad authority to intrude into local matters. The bill, and indeed emphasized stronger in the substitute, also eviscerates the rights of police to engage in collective bargaining. The bill authorizes courts to fashion injunctive relief to anything the AG perceives as leading to the single violation of law that started the investigation. Is the department understaffed, and this may have contributed to the violation? How about injunctive relief to cut vacation, prohibit holidays, force overtime? All done in violation of the collective bargaining agreement, but pursuant to the injunctive relief authorized by the bill. Indeed, the substitute bill goes even further and expressly prohibits collective bargaining that conflicts with the bill. Since the bill is incredibly broad, nearly every aspect of an employee's working conditions would be impacted and potentially prohibited for collective bargaining. I would hope everyone here would consider themselves a friend of organized labor, and yet here's a bill that completely eviscerates collective bargaining, but of course only if you put on a uniform and a badge. Finally, the bill will result in local jurisdictions simply conceding out of fear of ruinous cost. No jurisdiction is going to expend millions of dollars in legal fees, then be on the hook for potential damages and to pay the Attorney General's legal fees if they lose. It is notable that the bill does not allow the locality to win their attorney's fees if they win, only to pay the AG if they lose. Quite the stacked deck. The end result will not be any fair proceeding or any careful consideration of the issues. The end result will simply be throwing local police under the bus to avoid the unbelievable costs involved in mounting a defense. We ask you to reject Senate Bill 5066. Thank you.
Thank you so much. And Shalia, I'm so very sorry for mispronouncing your last name. But please go ahead.
Thank you, Chair Dhingra, and thank you to the esteemed members of the committee. I'm Shalia Stallings-Ala-Ilima, testifying in support on the proposed bill on behalf of the Washington State Attorney General's Office. I'm an Assistant Attorney General in the AG's Civil Rights Division. I've been with the Civil Rights Division since 2016. Our work is civil law enforcement. We enforce the law when there has been more than one violation or when a practice has capacity of harming multiple members of a Washington community. This bill would provide tools for us to use in following up on allegations of significant or widespread misconduct occurring at a department. The bill clarifies existing authority, but also importantly gives us tools that will allow us to more effectively serve Washington. Because we know in our experience, pre-suit investigation allows us to avoid litigation, reach agreed resolutions where changes are warranted, and close matters when no enforcement is necessary because there has been no violation of law. Our expectation from this bill is that these will not be everyday occurrences. We view this as an effort to provide guardrails to ensure departments are not violating the law. Thank you for the opportunity to testify. Happy to answer your questions.
Thank you so much. Go ahead, Michael.
Great. Thank you, Madam Chair, members of the committee, and Mr. Ranking Member. For the record, my name is Michael Transu, and I'm here today representing about the 4,000 members of the Washington State Fraternal Order of Police in support of Senate Bill 5326, giving the Attorney General some investigatory authority where insufficient accountability system and policies, training, and oversight practices create an atmosphere that leads to or accepts inappropriate behavior among officers. The communities we serve rightly expect more accountability for the actions of peace officers, and in our experience, a lot of the root causes of unacceptable actions by officers in the field can oftentimes be directly related to the agency's culture, hiring practices, or training protocols. We support 5326 because it's not intended to address the acts or hold individual officers liable for misconduct, but rather seeks to engage law enforcement agencies in consistent quality policing and agency accountability. It recognizes that Senate Bill 5051, which you adopted in 2021, is the place where individual officers can be and are held accountable for their improper actions and misconduct. It focuses on law enforcement agencies where there are, as the bill notes, insufficient accountability systems, training, and policies that lead to inappropriate patterns or practices. And it requires, we believe, significantly coordination with the U.S. DOJ and requires the AG to confer with the DOJ and the Washington and moving resources so that you're not double doing an AG investigation and a DOJ investigation. We've submitted some suggested amendments to the prime sponsor who is taking them under consideration, and we appreciate those incorporated into the substitute should it move out of committee. Thank you, Madam Chair.
Thank you so much, Michael, for that. Next, we're going to hear from Heather Kelly, and on deck will be Patrick Husting. Go ahead, Heather.
My camera's not working, but if you can hear me, I will go ahead. Can you hear me okay?
Yes, we can hear you just fine.
Okay, wonderful. Good morning, Chair Dhingra and members of the committee. My name is Heather Kelly, and I'm an attorney volunteering with the League of Women Voters of Washington. We are a nonpartisan organization with members and supporters in every county of the state. I'm here to speak on the League's behalf in strong support of Senate Bill 5066. Simply put, the League views this bill as a matter of good governance, a perspective not often raised when talking about law enforcement accountability. Local police officers are the most public-facing representatives of the executive branch of government, even at the local level, and Washingtonians deserve to know that the folks enforcing the law in their name are also held accountable to it. This is where the concept of checks and balances becomes so important, particularly clarity around those checks. The strength of our democracy depends on the ability of different branches and levels of government to maintain a balance of power between them. When the scales tip too far in favor of one level or branch and over another, or when there is a dispute about the scope of one branch's authority, it erodes public trust in government overall. This bill codifies the authority of the Attorney General to investigate cases over which it already has authority to bring suit. I don't read that as redundant, nor does it seem to be a sweeping change in authority, but rather an important clarification of authority. This bill would make it plain that the Attorney General may investigate whether systemic misconduct has occurred at the local level. Answering that question expeditiously is of critical importance when the public trust lies on the line. And finally, it's unfortunate that we often frame accountability as a product of opposing forces, as hurting partnership and government rather than helping it. Earning broad public trust should be, and I believe is, a goal of the majority of officers and agencies at every level of government. So framing this as an evisceration of officer rights is counterproductive. This bill is a powerful reminder of what Washington agencies can accomplish when they work together. Please vote yes on this bill.
Thank you so much. And Patrick is not on Zoom, so if you're here in person, now's the time to walk on up. The other person who's not on Zoom is Jacob Schmidt, so if you're here in person, now's the time to walk up. Okay, with that, we are next going to go and hear from Juan Perales. Good morning, Juan.
Good morning. Thank you, Chair Dinkra and the members of the committee for allowing me to speak today. I believe that this bill not only will build trust, but will also build accountability in law enforcement. And authorizing the Attorney General to investigate police misconduct in law enfortment and correction centers is a long time coming. We want to say that we have a problem in police that I think will speak to why we're having problems in recruiting officers into police agencies, and that is the element of white supremacy. That now there's more, people actually targeting police as a result of that. And as a result of that, who wants to go into law enforcement if they're being targeted? So I think that law enforcement needs to get back to their mandate of serving and protecting our communities. Okay. Now, the bill, it's a good thing about how it's going to get into correction centers because it'll prevent, I believe, what happened in Marcy Correctional Facility in New York, where we all saw on national TV the brutal beating of Brooke Roberts, that eventually died the next day. Also here in Linwood Police Jail, we had a woman that hung herself. And this was due because of neglect of custody officers to check on her on an hourly basis as is policy. Between 12:01 and 3:01 p.m., there was no check on this woman. When they found her, she was irresponsive. So I believe that this bill should help change the culture of policing that is so much needed because too many people die in the hands of police, and disproportionately, blacks are overrepresented in those numbers of 1,100 on average on a yearly basis over the last 6 years. So they only make up like 13% of the population, yet there are 24% of those people that die in the hands of police. I want to thank you for letting me speak on this, and I also believe that this is a bill that will turn the wheel of justice in the right direction. Thank you very much.
Thank you so much. Next up will be Robin Emmons.
Good morning, Chair and members of this committee. My name is Robin Emmons. I'm a criminal defense attorney in Yakima, and I'm testifying on behalf of the Washington Association of Criminal Defense Lawyers and the Washington Defender Association in support of Senate Bill 5066. I have been in practice for about 18 years. I have defended both civilians and law enforcement in accusations of wrongdoing. I have jailed clients waiting patiently for access to care and who have experienced other problems while in custody. This bill is healthy for communities struggling with a lack of trust between law enforcement and corrections on the one hand and civilians on the other. Current practices for investigating wrongdoing vary wildly across the state, geographically and over time as leadership changes and budgets fluctuate. There's also tremendous pressure put on local investigators who are asked to take a critical look at their peers when misconduct is alleged. There's an understandable instinct to protect brothers and sisters in uniform. I feel it, and my job is to criticize them much of the time. This comes with resistance to outside scrutiny, despite the fact that law enforcement should have nothing to hide. Both police and the folks who are entrusted with our jailed community members have a sacred trust to care for the lives of the vulnerable as they seek to enforce order. When that trust is violated, statewide consistency in responding to allegations of misconduct can do much to soothe the turmoil that results, especially in smaller rural communities such as mine. Thank you for your time today and for your service to the state of Washington.
Thank you so very much. And the last testifier on this bill is Eliana Makchevsky. Please unmute and begin.
Hi, good morning, Chair Dingra and members of the committee. Thank you so much for the opportunity to provide testimony on this very important bill. My name is Eliana Makchevsky, and I'm a staff attorney at the National Police Accountability Project. We strongly support SB 5066 and Chair Dingra's proposed substitute bill. We see it as a bill that will provide critical tools to remedy and prevent violations of constitutional and statutory rights in Washington. The National Police Accountability Project is a nonprofit organization dedicated to holding law enforcement and corrections agencies accountable to constitutional and professional standards. And we have over 550 attorney members who litigate law enforcement and correctional misconduct in state and federal courts across the country, including within Washington. And as civil rights litigators, we know that the abuses our clients suffer are often not the isolated incident caused by an individual officer, but the result of department policies or practices that tolerate or even encourage such conduct. And due to various procedural barriers, our clients are often prohibited from seeking the kind of agency-wide change in policy and procedure through their civil rights suits, even if they have evidence that the harm they experienced was part of a broader systemic issue. And so SB 5066 is necessary to guarantee the kinds of agency-wide changes that would be able to prevent future misconduct and harm. As you all know, the Civil Rights Division of the U.S. Department of Justice is designed to fulfill this kind of government accountability mechanism, but just last week it announced a freeze of all civil rights litigation until further notice. And so a robust state-level accountability system has never been more important than now. As some of my other colleagues have testified about, several other states have granted their AGs similar powers, including Colorado, California, Virginia, Illinois, Nevada, and others. And they've had wonderful accomplishments that serve as a testament to the importance of this kind of AG authority. I wanted to add also that notably these measures in those other states have not impeded officer retention. And to the contrary, law enforcement employment levels in California sharply increased the year after it adopted its similar AG investigations bill. And in 2020, the year after Virginia's Attorney General investigation law went into effect, the state experienced a 21.7% bump in the number of sworn police officers. This is because this kind of investigatory and enforcement power is designed to, and in fact does, improve agency policies and practices. It improves public perception of law enforcement and public trust of law enforcement, and makes these law enforcement and correctional agencies better places for individual officers to work. We just want to again emphasize that implementing this SB 5066 will be very valuable to everybody, from law enforcement to members of the public. And we see it as a critical tool and urge you to pass SB 5066 out of committee. Thank you.
Thank you so very much. Senator Trudeau?
Thank you, Madam Chair. For those signed in not wanting to testify, there are 734 pro and 448 con.
Thank you so much. And I just want everyone on this bill to know that this is scheduled for exec hearing next Thursday. I do want to thank everyone for their participation. And for the people who testified, Khan, I would just like to remind you that Vice Chair Trudeau had asked a question which I didn't hear an answer to, and her question was, how do we ensure compliance? So when you provide feedback, I would love to actually hear an answer to that question so that we can incorporate this into the bill. And with that, public testimony on Senate Bill 5066 is completed, and we are adjourned.